Welcome to U.S. Immigration TV. Well, over the course of my approximate 40 years of practicing law and having tens of thousands of people consulting with me, there are several situations or mistakes that people keep making. Now, they may seem obvious or simple to many of you, but to others, the effects could be devastating, causing years of delay, denials, and additional years of unnecessary separation from your family members. Well, in this video, I'll discuss several of the more common mistakes or misunderstandings that many people have. Maybe they apply to you directly or perhaps to someone you know. So make sure to share this video with others, as perhaps it could help them. And as far as I'm concerned, even if this video is able to help one person with their immigration problem or be reunited with their family, it would have been worth it for me. Okay, so now let's go through some of the more common immigration mistakes I've seen over and over throughout the years. Number one, petition children left behind right away. So in many cases, a person is under petition, but they have to leave a child behind, perhaps because the child had aged out. Or maybe they were petitioned as a parent of a U.S. citizen, and they could not include their other children. So now, once they arrive in the U.S., they seem to take no further action in connection with the child left behind. You know, I've seen many cases where, for example, a person, may have immigrated in 2015, and are only now inquiring what to do about the single child they left behind. So, I asked them, why didn't you file a petition for that child in 2015 when you first got here? And why are you only asking about it now? And so what happens basically is I get a shrug of the shoulders or something like, I didn't know, or something else like that. Therefore, if you left behind a single child, you should take immediate steps to petition them as soon as possible. Number two, green card holders or lawful permanent residents can petition certain family members. Well, some people mistakenly believe that only U.S. citizens can petition family members. This is wrong. Immigrants or green card holders can petition their spouses and unmarried children, whether the child is under or over 21 years of age. You don't have to wait to become a U.S. citizen in order to petition these family members. So if, for example, you left behind a child and that child is single, you can file the petition right after you get your green card versus, waiting years and years to become a U.S. citizen and then petition them. Number three, it could be faster to petition a family member while you are an immigrant or green card holder rather than waiting to become a U.S. citizen. I've seen many people having delayed filing petitions for their family members until they became a U.S. citizen, thinking it would be faster. Again, this is wrong when it comes to petitioning spouses or unmarried children, F2A, F2B. As I've already discussed, green card holders can petition spouses and unmarried children right away. Waiting until you become a U.S. citizen would not make it faster. Instead, it would actually create delays. Now think about it. If you wait to become a U.S. citizen, first, ordinarily, you have to be a green card holder for 5 years. Then it takes at least another year or more before you can finally naturalize. Well, that's already 6 years before you're finally filing a petition. But if you had filed the petition for your spouse or unmarried child as soon as you got your green card, they would be that much closer to being eligible to be processed for their green cards, at least 6 years ahead. Now, of course, if you are going to petition a married child or brother or sister or parent, then of course, yes, you must be a U.S. citizen. But as I said before, you can petition a spouse and unmarried child right away as a green card holder. And also, if you later naturalize, that's okay, because your existing petition could convert from a petition of an immigrant, to a petition of a citizen, and the family member keeps the original priority date. Number 4, see an attorney right away after a denial. Well, what's happened is people have consulted with me in situations where, for example, they come and they say, oh gosh, in 2017, my adjustment was denied, or a family member's visa was refused at the US Embassy, etc. And they're only now, years later, coming to an attorney to ask what could be done. So my advice is, if you have a denial and you want to see if there's anything that can be done about it, you should see an attorney right away versus waiting years and years. After all, appeals or motions to reconsider have strict time limits. In addition, even if the case was wrongly denied and could be overturned, you've already wasted several years of separation. And of course, I'd also say that you should probably have had an attorney handle it from the outset versus yourself, which could have greatly increased your chances of success, of course, rather than handling it on your own and possibly getting a denial. Number 5, for a child's eligibility under the Child Status Protection Act, the child must seek to acquire a visa within 1 year of when the priority date became current. Now, under the Child Status Protection Act, there is a 2-step process ordinarily to determine their eligibility and their entitlement to benefits under the Child Status Protection Act. Now, first, there's a mathematical computation to determine if the child's age is calculated to be under 21 years of age. And I'm not going to discuss that in this video. Instead, there is a second step that if the child's age is calculated under that mathematical formula to be under 21, the child must also, according to statute, seek to acquire a visa within 1 year of when the priority date became current, such as if they're in the US filing for adjustment of status if they're eligible, or if they're outside the US submitting a DS-260 at the US Embassy, etc. Now, I have encountered so many cases where a child who had aged out was mathematically considered to be under 21, but the family neglected to pursue that child's visa within 1 year of when the priority date became current. And in that case, because they did not seek to acquire a visa within 1 year, the kid could be out of luck. Number 6, keep copies of all your immigration records in a safe place. Now, in some cases, the waiting time for an immigrant visa or petition can be up to 20 years. Now, I've had some people consult with me about their immigration case, but then they say that they lost all their records. In other situations, a person may have had their case denied, but they lost a copy of the denial or that decision. They may have moved several times and they just don't know where their records are. Obviously, without those records, without the decisions, without the case, it's hard to evaluate their case or their chances of success. So my advice is you should gather your records and keep them in a safe place. And of course, in our age, they can be scanned and put in some sort of PDF folder on your computer. Of course, it could be possible in some cases to request a copy of a person's immigration file from the government. But that could create additional delays and perhaps those records may no longer be available. So make sure you gather all your records related to your immigration situation and keep them in a safe place and keep track of them for when you do consult with an attorney. In fact, I've already posted a video on the types of documents a person should gather and save, especially in connection with a possible amnesty if and when it should ever happen. Number 7, advise the USCIS, the NVC, or the embassy of any address change or other changes in your immigration situation. In many cases, a person had been petitioned and the priority date was current, but it was later discovered their case had been terminated and they lost their priority date because they failed to notify the NVC that they had moved. Terminating a case is what's called a 203G termination. And what happens was when the priority date became current, the NVC had sent notices to them, giving them 1 year to respond. And of course, because they moved, They never got that letter. So the year went by, and therefore the case was terminated or shred. Now remember, it is your obligation to notify the government of your current address. If you move and you don't let them know, they'll send notices to your old address. The postcard you give to the post office is not sufficient. That expires after 1 year. You have to notify the governmental agency directly and make sure you notify the correct agency. If your file is with the NVC, you have to let the NVC know, not necessarily USCIS. Remember, the government's not going to go and try and track you down. It's your job to let them know of your current address. And finally, number 8, monitor your priority date. Now, everyone knows it could take years for a priority date on some petitions to finally become current. And people have come to me for consultations, and it appears their priority date had been current for several years, but they had done nothing. When I asked them about it, they say that they were somehow waiting for the government to send them some kind of notice. As I said before, the government is not going to track you down if you move. And if the priority date becomes current, the NVC may send out a notice to you, giving you 1 year to respond. And because you are not aware the priority date became current, you may miss the 1 year deadline and the case will be shred and canceled. So I've posted several videos about the priority date, and I of course invite you to watch those videos explaining how they work. In addition, on my law office website and Facebook account, I do post the priority dates every month. So you need to check and see, whether on my website or the U.S. State Department's website, check the priority date on your case and see if the petition is already current. And if it is, you may need to act fast and possibly even see an attorney. Now, these are some of the more common mistakes or oversights that I've encountered during my consultations. And of course, I have dedicated this channel to providing you with what I hope to be useful information. And of course, I hope you have found this video informative and helpful. If not for you, maybe for somebody you know. So let me know in the comments, and make sure, of course, to like, share, and most importantly, subscribe to this channel for further information, updates, and news. I'm Michael Gurfinkel, and thanks for watching U.S. Immigration TV.